Senators and members of Parliament, we have a quorum. As Senate Joint Clerk of your committee, it is my duty to preside over the election of the Senate Joint Chair. I am ready to receive a motion to that effect. Are there any nominations? Senator Harder.
Thank you. I move that Senator Boniface be elected as the Senate Chair of this committee.
It is moved by the Honourable Senator Harder that the Honourable Senator Boniface take the chair of the committee. Is it your pleasure, Honourable Senators and members of Parliament, to adopt the motion?
Agreed.
I declare the motion carried. I invite Senator Boniface to take the chair.
Members of the committee, I look forward to working with you. We will now proceed to the election of the Senate Deputy Chair. I am ready to receive a motion to that effect. Are there any nominations?
Je propose le sénateur Claude.
I propose Senator Claude Carignan.
Moved that the Honourable Senator Claude Carignan be the Senate Deputy Chair of this committee. Is it agreed to adopt the motion? Agreed. I declare the motion carried.
Honourable members, we can now proceed to the election of the chairs from the House of Commons. Pursuant to the order adopted by the House on March 2nd, 2022, the House co-chairs will be from the Bloc Québécois and the New Democratic Party. I'm now prepared to receive motions for the co-chair from the Bloc Québécois.
Oui, bonjour, Madame la Présidente.
Yes, hello, Madam Speaker. I propose my colleague, the Honourable Réal Fortin, as co-president.
By Ms. Bendayan, that Monsieur Fortin be elected House co-chair for the Bloc Québécois. Est-ce que c'est la volonté du comité d'adoption?
Is it the will of the committee to adopt the motion? I declare the motion carried, and Monsieur Fortin duly elected House co-chair from the Bloc Québécois of the committee.
I'm now prepared motions for the co-chair from the New Democratic Party. Sir?
Mr. Chair, I can propose that and to move that Matthew Green be the co-chair from the NDP.
It's been moved by Mr. Brock that Mr. Green be elected House co-chair from the New Democratic Party. Is it the will of the committee to adopt the motion? I declare the motion carried, and Matthew Green duly elected House co-chair of the committee representing the NDP. I will now invite both chairs to take their seats. We'll now proceed to the election of the vice chairs for the House of Commons. Pursuant to the order adopted by the House on March 2nd, 2022, the committee shall elect two vice chairs from the House, of whom the first vice chair shall be from the governing party, and the second vice chair shall be from the official opposition. Le premier vice-président agissant.
The first House Vice Chair shall be from the governing party. I am now prepared to receive motions for the first Vice Chair.
Be elected as first Vice Chair of this committee.
Mr. Naqvi has moved that Mr. Varani be first Vice Chair of the committee. Are there any other motions? Is it the will of the committee to adopt the motion? I declare the motion carried and Arif Farani duly elected first vice chair of the committee. Le deuxième vice-président.
The second vice chair shall be from the official opposition party. I am now prepared to receive motions for the second vice chair from the official opposition.
Move that my colleague Glenn Motz be nominated as the second vice chair.
Mr. Brock has moved that Mr. Mott be elected the second vice chair of the committee. Are there any other motions? Is it the will of the committee to adopt this motion? I declare the motion carried and Mr. Mott's duly elected second vice chair of the committee. I will now turn the meeting over to Senator Boniface. Thank you.
Thank you very much. We'll now move to proposed routine motions, starting with motion number 1 regarding analyst services. Do I have a mover for motion 1? Senator Harder? It's moved by Senator Harder that the committee retain as needed and at the discretion of the chairs the services of one or more analysts from the Library of Parliament to assist it in its work. Is it agreed to adopt the motion? Carried. I will now invite the analysts to come to the table. Thank you very much. Colleagues, perhaps we could take a moment and let the analysts introduce themselves.
Hello, everyone. My name is Stephanie Feldman. I'm one of the 2 analysts that is assigned to this committee, and I'm really looking forward to assisting the committee with its work.
Bonjour tout le monde.
Hello, everyone. I'm Brendan Deff.
Previous Senate committees or House of Commons committees, and a lot of new faces as well. Look forward to working with my colleague Stephanie and with yourselves.
On behalf of the committee, we welcome you aboard. Motion number 2, the Subcommittee on Agenda and Procedure. Do I have a mover for motion 2? Mr. Motz? It is moved by Mr. Motz that the Subcommittee on Agenda and Procedure be composed of the chairs, the vice chairs from the House of Commons, and all 4 Senate members of the committee, and that the subcommittee work in a spirit of collaboration. Is it agreed to adopt the motion? Mr. Fortin?
Piètre président.
I'm a poor president because I'm not sure how to take the mic in this committee, which I'm co-presiding, but I would like to have a discussion, and I think maybe this is the right moment to talk about the subcommittee, because I notice that we will have 8 members in the committee, which will be members of the subcommittee, and that, contrary to our usual, they will not make decisions. They will simply report to the committee who will approve or not the subcommittee's propositions. But here, this is going to be a decisional subcommittees, and 8 of us will sit on it, where we are 11 in total. So I was thinking that discussing amongst 11 people or 8 people is not really harder, and that quite possibly it may be more democratic and more pleasant in general for all of us that all 11 members of the committees take these decisions together, make these decisions together. So I wonder if there's an opportunity here to create a subcommittee or not, considering the actual situation where we have a certain number in the subcommittee, and this subcommittee will have decision-making power. So I'm just raising the question, and I'll let you speak.
Madame Badelet?
Bendayan, oui, merci, Madame la.
Hello, Madam Co-President. Co-Chair. I actually agree with Mr. Fortin's proposal, but I believe that we need to make sure that we that we have a certain level of efficiency in our discussions to move forward. So between 8 and 11 members, I believe that what my colleague is proposing makes a lot of sense.
Comments? Senator Harder.
Very quickly, I have no objection. I think there's some logic to this.
Madam Chair, my hand is raised. It's Arif Irani online.
Please go ahead.
Thank you. So first of all, welcome to everyone. Congratulations to you, Madam Chair, and to all the co-chairs, vice chairs, deputy chairs. There's a lot of terminology being thrown about, and congratulations to the analysts. Look forward to working with everyone on this committee. It's going to be very important and precedent-setting work. I think when you analyze actually the terms of the proposed motion, it would actually end up including only one member of the Liberal Party, and I think that renders an unfairness on its face. So I would be very supportive of what Mr. Fortin is suggesting, that if there is a subcommittee struck with only one Liberal member, because there's only one Liberal amongst the chairs and the co-chairs and vice chairs, that instead it only make recommendations and not make formal decisions, but that the final decisions be referenced to the entire committee and referred to the entire committee only. Thank you.
Thank you very much, Mr. Motz.
Thank you, Madam Chair. It would strike me then if we are looking at this from a subcommittee perspective that we could either eliminate 2 and 3 completely or add that in 3 they have the ability to make some decisions on witnesses, but they bring it back to the committee for approval, and that would be a friendly amendment that I was going to propose once we get to number 3, that the approval of what the subcommittee's work come back to the main committee, to this committee for approval. And it's not as efficient, but it could work. So it's one or the other. I suppose we eliminate them completely, or we have changed the wording to allow approval to come back to this table.
Any other comments? I'm sorry, Madame Dayan.
Merci. Peut-être quelques autres
Maybe just a few more reflections as far as the discussions that we would have in place of the subcommittee. As a committee, can we agree that those discussions would be in camera or in private rather than televised, considering that the subcommittee's work would not be televised? So if we go ahead in that manner, then I would just need confirmation.
The way we may wish to deal with this motion, if I'm seeing consensus around the table that we do it as a full committee, as Mr. Fortin has proposed, and trying to work with as much efficiency as possible, that the best way to do it would be just to defeat motion number 2 and not deal with, not propose number 3. Would that be agreeable to everyone? I think that meets your purpose, and I think I'm hearing around the table that we want efficiency, but at the same time, the difference between 8 and 11 is not significant. Have I read that correctly? Okay, then. On number 2, if I've heard you correctly, then I would ask, is it agreed to adopt the motion?
Madam Chair, would we agree that the discussions would be in camera?
I think...
Je sais pas.
I'm not sure, actually. In my opinion, and you may or may not agree, but in my opinion, our discussions should be public when they can be public and be in camera when we are obliged to be in camera because of the Act. So at this point, I'm not sure, or I don't quite see how we can determine what should be in camera or not, but I wouldn't want us to adopt a motion that would force us to be in camera without good reason. I think we've all seen the Act, and we've seen that orders and regulations that are not going to be in the official gazette should be studied in camera, and of course that makes sense. We don't want anyone to compromise state security. But at this point, should we adopt a motion to be in camera? And I don't think so, quite respectfully, Ms. Bendayan. I think that we don't need the subcommittee at all, but I'll leave it to the discretion of the entire table.
To be followed by Senator Carignan.
Can I just withdraw my motion? That'll be easier, then we don't even deal with it.
We could do that. Can I just, so that's
Yes.
a proposal you have on the table. Can I go to Senator Carignan?
Please.
Yes, I was in the same space as Mr. Fortin, and I believe that if the committee is working together, then what needs to be public should be public without removing anything that needs to be in camera according to its more sensitive elements as concerns national security. But everything should not be in camera.
I have heard you all correctly.
Madam Chair, could I intervene on this very same point, please?
Oh,
Madam Chair?
pardon me. Sorry, I couldn't see your hand. Thank you. Go ahead.
Thank you, Madam Chair. No, I appreciate that. I'm just trying to reflect on sort of, I think it's absolutely wise that we are moving away from a subcommittee. So I think we're all in agreement on that. But as to whether matters that are administrative in nature, such as the scheduling of meetings, the timing of meetings, the witnesses allocation between parties or Senate groups, these are rather mundane and administrative matters. In my parliamentary career, I've never seen such matters ever discussed in public. I don't think the public has a strong public interest rationale for being privy to those kinds of conversations. I think transparency is important in terms of what Monsieur Fortin is mentioning, but that's the transparency vis-a-vis the witnesses coming, their testimony, and the questions that are asked of those witnesses by the various members and the responses that are heard. That is what we have a critical public interest in being transparent with Canadians about. I'm not sure about whether we have a meeting on April 10th or April 11th and the length of that meeting and how many witnesses appear for what length of time is particularly salient or important for Canadians to be privy to. So to my mind, when we're discussing routine matters such as scheduling of witnesses, that should be done in camera. Thank you.
Anyone else? Senator
Madame
Harder?
la Présidente,
Madam Chair, I'm not seeing a proposition here, and there's no mention of being in camera. Am I missing something? Is it mentioned elsewhere in the text? Maybe this would resolve the issue.
Didn't deal with this particular motion that we would in fact ensure that there will be some discussion in camera in terms of, I think, the more mundane issues, if I can use that term, if I understood correctly. Senator Harder, do you have a solution for us?
Well, it seems to me that we've all agreed that the whole committee should be a party to the discussions on procedure and the agenda. But I would suggest that when the committee is dealing with procedure and agenda, it do it in the normal in-camera fashion so that we can have a not public conversation around who we hear and what timeframes, but that our committee work, I totally agree with the bias. Our bias should be on transparency, except for issues around security on which we'll have to take advice. But let's do the sausage making in camera. Acting as a committee, as a subcommittee of agenda and procedure in the whole committee.
So I think we're seeing agreement around the table, and I think what we'll have to do is just move it as we go. We'll come to those issues that we can then have the discussion whether it would necessarily move in camera or not. Is that suitable to everyone? Yep. So then for this motion, then Mr. Motz, would you be agreeable we withdraw the motion?
Yes, I'd withdraw that motion, please.
Thank you. And I think it would therefore apply to motion number 3 as well. That would be withdrawn. Okay, then we'll move to number 4, communications. Do I have a mover for motion 3? Oh, pardon me, motion 4. Thank you. Okay, Mr. Green. It's moved by Mr. Green that the chairs be empowered to direct communication officers assigned to the committee in the development of communications plans and products where appropriate, and to request the services of the Senate Committee, the Senate Communications Directorate and the House of Commons social media team for the purpose of promotion of the committee's work. Is it agreed to adopt the motion? Agreed. Motion number 5, a time for opening remarks and questioning of witnesses. Do I have a mover for the motion 5? Yes, sorry.
In motion 5, there's no reference to Senate for second round. Is that an oversight or intentional?
Madam Chair, I'd like to speak to that as well. I have a proposal to make a friendly amendment to number 5.
Can we move it first and then do the amendment? Is that the... Senator Hart, moved by Senator Harder. That witnesses be given 5 minutes to make their opening statement, that whenever possible, witnesses provide the committee with that opening statement 72 hours in advance, that at discretion of the chairs, the order of questions for the first round of questioning should be 4 minutes Conservative House of Commons, 4 minutes House of Commons Liberal, 4 minutes House of Commons Bloc Québécois, 4 minutes House of Commons New Democratic Party, and 4 minutes for each senator, and that the questioning during the second round shall be divided as follows: 3 minutes House of Commons Liberals, 3 minutes House of Commons Conservatives, 3 minutes House of Commons Liberal, 2 minutes House of Commons Bloc Québécois, 2 minutes House of Commons for the NDP. We have an amendment, Mr. Mott? Oh, pardon me.
I've been informed that there's a difference in procedure in the House and the Senate, that the second round in the House is different concept than in the Senate, so I withdraw my comment.
Thank you. I was going to ask the clerk to explain that, but we had that discussion. Mr. Motts, you have an amendment?
Thank you, Madam Chair. I'm fine with the motion as moved to the up and including during the second round shall be divided as, and from there I would suggest that it read as follows: 3 minutes House of Commons Conservative, 3 minutes House of Commons Liberal, 2 minutes House of Commons Bloc Québécois, 2 minutes House of Commons NDP, and 2 minutes each for each senator.
Madam Chair?
Please.
Can I ask Mr. Motts, can you repeat the amendment just to make sure that I have it, please?
So the wording up until during the second round should be divided as follows. It remains the same in the motion. The change will then be 3 minutes House of Commons Conservative, 3 minutes House of Commons Liberal, 2 minutes House of Commons Bloc, 2 minutes House of Commons NDP, 2 minutes each for each senator of the 4 senators.
Thank you.
And just as an addition to that, this would go generally in line with how many of the committees are operated now in the House.
Just to clarify, for my purposes, Mr. Motts, you're reversing the order, the Conservatives first and then Liberals second. Is that intentional?
It's in line with how the first round is. First
Okay.
round is Conservative, second round is
Okay.
Liberal, and the second, no, sorry, it's Conservative, Liberal, Bloc, NDP, and then in the second round would be follow the same rotation: Conservative, Liberal, Bloc, NDP.
Any comments on the amendment?
Madam Speaker, I had a comment. It's a read for Annie online.
Thank you. I apologize, Mr. Barney. For some reason, when your hand goes up, just because there's a tree behind it, I don't see it on this angle. So I apologize I'm not ignoring you. Go ahead.
Madam Chair, I wish that was a tree. This is my rented condo, and that is a pretty fake tree. So it's always going to be green. But thank you. Sorry about that. In terms of the allocation of the timing and the ordering in round 2. So again, I'm not privy to Senate practice, but pursuant to House of Commons practice, I believe we normally do invert it. So if the official opposition goes first in round 1, the government usually goes first in round 2. So that's my understanding of the practice. And the second point is that I guess we're in a bit of a sort of a special situation here, and that is because it is a committee of 2 houses. And among the Senate group, there was such a thing known as a liberal Canadian senator in the past, but there is no longer. But the same does not apply to all of the other parties, including the official opposition. So the unfairness that I'm pointing out here is that when we allocate additional time to the senators, that includes Senator Carignan, who is a member of the Conservative caucus. And that would, from my respectful submission, present an undue unfairness where you would have multiple opportunities for Conservative members of that party's caucus to speak, including 2 members of the House and the Conservative senator. The same cannot be said for any of the other senators. So we can't create an equality by propping up the amount of speaking time of a Liberal senator because there are no Liberal senators. So I raise that for the committee's consideration, because I do think that renders some unfairness with respect to my party and the speaking time we were being allotted. Thank you.
Thank you. And Mr. Green?
Perhaps by way of finding some kind of common ground here, I would suggest that maybe we consider having a Senate rotation on a fifth slot. So rather than having all of them, perhaps we could rotate through the groups. I can state with a surety that we do not have a new Democratic senator, although maybe some that are close. We certainly do not officially have a new Democratic senator, but maybe one way to find common ground between the two alternatives would be to provide a slot E where we can have a rotation through senators, and that could be determined by the senators, notwithstanding the fact of having to exclude somebody in a way that wouldn't allow them to participate. So it would be my suggestion that perhaps there is probably liberal-leaning senators, as there's probably, other senators that tend to lean in different partisan ways. So that would be my suggestion as perhaps a way forward to find that common ground.
Next, Senator Carignan to be followed by Mr. Brock to be followed by...
Je voudrais juste commencer à...
I'd like to say that we should be careful when we try to give labels to senators. There is no senator from the Bloc Québécois either. So if we start to use that type of argument on the Senate side, well, we're not going to go and do blood tests to find out who's red and who's blue and so on and so forth. I think that my colleague, Mr. Motz's proposal is reasonable. There is some balance there. I think that all senators can agree to say that we are quite independent amongst ourselves, and that applies to all of the senators here on this committee.
Thank you to Senator Carignan. Mr. Brock?
Thank you, Madam Chair. I want to start off by indicating my support for my colleague Glenn Motz's suggestion with respect to the second round of witnesses. And with all due respect to my colleague, Mr. Varani, my understanding, my brief experience as a parliamentarian sitting on the Justice Committee and occasionally on public safety, on the second round, the opposition party goes first, not the governing party. So I'm not sure if his committee work is a little different, but at least 2 of the committees that I sit on, second round is always led by the Conservative Party. Thank you.
Madame Bandayan?
Thank you, Madam Chair. And in the spirit of collaboration, I would be very, very comfortable and indeed happy to support if the proposal that the official opposition goes first on the second round. I would like to just pick up on a point that Mr. Green mentioned just a few moments ago to indicate that quite apart from any partisan reasons or purposes, I would point out that it is important for each member to have the opportunity to ask questions, but that is not the case. Quite simply, we are 3 members on this side, and we only have 2 slots. And so, de facto, the way that the committee will operate is that not every single member will have an opportunity to ask questions at every single panel. So I think that this is something to keep in mind, and in the spirit of fairness that we try and give equal weight to that argument as well.
Thank you, and certainly appreciate, through you, Madam Chair, those thoughtful remarks.
And in the same spirit of how the governing side will likely have to rotate within their own coordination, that actually lends weight, I think, to my suggestion that the Senate do the same, notwithstanding the fact that we understand the Senate tends to work fairly well in those regards and would likely be able to figure out a rotational basis in the same way that we're figuring out rotational bases to chair. I just want to remind people just the unique nature of this committee. And in fact, the way in which we're constituting hopefully a very collaborative and nonpartisan blueprint for other like committees, should this ever have to happen again, to work on a move forward basis. And so if what I'm hearing, and maybe there's that spirit that the Conservatives would get to lead the second round and we would not have every senator but a senator in the second round, then I think that that's a vast improvement on what was proposed in the original draft and finds us in that agreeable space. Thank you.
I have Mr. Varani, then Mr. Brock, and then Senator Harder. Mr. Varani, please go ahead.
Thank you very much. I hope the plant wasn't in the way this time, Madam Chair. In response to Senator Carignan, I would just simply say that the facts are the facts, sir. I mean, there's one senator on this team that sits as a member of a party caucus, and that is you. And that's for Canadians to verify themselves. On the second point, I would say that I'm in complete agreement with Ms. Bendayan that either we keep the extra 3 minutes that was allocated to us so that every Liberal on this committee, not on a rotation, but on every meeting, has the chance to ask questions, or we ensure that the Senate goes into a rotation, because as proposed by, I believe it was Mr. Motz, you could have a situation where 2 out of the 3 Liberals in a given meeting get to ask questions, 1 does not, and every senator gets 2 opportunities to ask questions. That is a patent unfairness that is not, to my mind, acceptable. Thank you very much.
Mr. Brock.
To address my colleagues, Mr. Varani and Madame Bendayan, they raise interesting issues, and it's a trend that I've been seeing on the Justice Committee. We have to ensure equities. We have to ensure that every party has an opportunity to have equal opportunity to ask those questions. There is a simple solution to this, and that is our ability to control the number of witnesses per session. Thank you.
Senator Harder to be followed by Mr. Motz. Senator Harder?
Not speaking for any other senator, I'd be happy to accept the notion of rotation among senators by witnesses. Thank you.
Mr. Motz?
Thank you, Madam Chair. In light of the discussions, I would amend my own motion, or to read like Mr. Green has suggested, that 3 minutes Conservative, 3 minutes Liberal, 2 minutes Bloc, 2 minutes NDP, followed by 4 minutes, 2 for each rotated senator, to be determined by the Senate group themselves.
The motion amended, is that agreeable to everyone? I think that incorporates all of the discussion.
Madam Chair, could I just get clarification from Mr. Motz just about the last piece? So it was 4 minutes for the Senate. Could you just repeat that, please?
Yes, Mr. Varani. I'm proposing that 2 senators speak for 2 minutes each. So that'll be 4 minutes total for 2 senators, and the rotation is they determine themselves within the 4 senators who would speak in that length of time.
I'm seeing agreement from the screen from Mr. Varani. Thank you. Do we have agreement on that amended motion? Thank you very much. Well done. Okay, we'll move to motion number 6, document distribution. Do I have a mover for motion 6? This is moved by Mr. Brock. That the joint clerks of the committee be authorized to distribute to the members of the committee only documents that are available in both official languages, that witnesses be advised accordingly. Is it agreed to adopt the motion? Motion number 7. Do we have a mover for motion 7?
Madame la Présidente, avec votre permission.
Madam Chair, with your permission, I'd like to go back to motion 6. I'm sorry, I wasn't fast enough. There is a typo in the translation that should be corrected. It says only the co-clerks, joint clerks should be authorized.
The committee only document. Alors, il y a deux fois seul dans la version française, mais une.
So in French, we say only twice. So I think it's just a little typo that should be corrected. That only the co-clerks, joint clerks, be authorized to distribute members to the committee only the documents that are available in both official languages. But the only, le seul, seems superfluous, and I think it's just a mistake. So we should remove that only the clerks be allowed to distribute documents and that they be in the official languages. I think this is the spirit of the text, and this is what is read in the English version. So we added this notion of only. On the French version, it's not necessarily significant, but just to make them match.
What I is suggesting is that the word seul in the French text be removed. And that is probably an editing error when I wrote it originally. My apologies.
Et dans le mot autorisé.
And then in the word authorized, there's an accent. There aren't two E's, so we could take out the second E. So it's not a substantive change, but since we're looking at it, why don't we correct it?
With my French experience.
Is the committee agreeable? It's a friendly amendment. Thank you. Thank you, Mr. Fartin. And we'll move back to motion 7. Do I have a mover for motion 7? Mr. Green? It's moved by Mr. Green that the joint clerks of the committee be authorized to make necessary arrangements to provide snacks and beverages for the committee and its subcommittee. Is it agreed to adopt the motion? Agreed? Motion number 8, committing and certifying accounts. Do I have a mover for motion 8? Senator Harder? It's moved by Senator Harder that either chair or in accordance with the direction of the chairs, either joint clerk be authorized to approve payment of expenditures of the committee. Is it agreed to adopt the motion?
Madam Chair, I apologize. I was a bit late to my button there before the motion was moved. May I suggest that maybe we come back to 8, or else I would just flag for my colleagues that we might wish to agree as a committee on any expenses of outside counsel.
Would you like to amend that as an exception, or how did you want to deal with it?
Madam Chair, if I may, to bring some light to this issue here, what committing and certifying accounts deals with is usually paying, my understanding is for paying for witnesses and for costs for that. Hiring, I can say on the House of Commons side, hiring outside counsel is a completely separate matter. It will require a separate budget and further approval by the committee. I would say that that aspect is not contained in this motion. However, I would also defer to my Senate colleague to see if he has anything to add on this subject as well. Thank you.
No, I was going to make the same comment that I believe hiring would be a totally separate motion and agreement of the committee.
That is an extremely useful clarification. Thank you to both clerks.
Go ahead.
So do we need clarity in this particular motion as to the point that both clerks are making, that hiring outside counsel is would that be clarified if there's a subsequent motion to that?
If I may, I believe our financial policy manual on the House side is quite clear that hiring outside staff requires a separate budget and separate approval. It's actually in the financial policy manual. I don't believe the two issues are linked at all. Thank you.
And just for clarity, it's the same on the Senate side. Are we okay then to move with the motion number 8? Agreed? It's moved by Mr. Green that if requested, reasonable travel accommodation and living expenses, including child care and or personal attendant care and/or the cost of approved headset be reimbursed to witnesses upon application, not exceeding 2 representatives per organization, and that in exceptional circumstances, payment for more representatives be made at the discretion of the chairs. Is it agreed to adopt the motion? Motion number 10. Do I have a mover for motion number 10? Mr. Brock? It is moved by Mr. Brock that each committee member be allowed to be accompanied by one staff member at an in-camera meeting, and that one additional person from each officer's office be allowed to be present, and for the Senate that the office of the leader of the government or the leader or facilitator of each recognized party or parliamentary group be entitled to one additional staff member at these meetings, provided that all committee members and staff present shall take the oath of secrecy as set out in subsection 62(3) of the Emergencies Act. Is it agreed to adopt the motion? Motion number 11.
Madam Chair?
Yes.
Oh, I'm sorry. Maybe I should have let you read it out before I jumped in. It's regarding the transcripts and in-camera meetings. I would just suggest that I actually oppose destroying documents and having a direction in the beginning of this committee to destroy documents of in-camera meetings. I just want to again reiterate the nature of this committee and the ability for us to provide blueprint, to provide detailed information on the spirits of discussions to those perhaps at a future date who may be seeking guidance of previous committees. I know how much helpful that would have been for us if we had that access. And that, of course, underscores and understands that if we were to maintain these documents, that we would be doing so knowing that those in future proceedings would also have to have the kind of security clearance that would be necessary. And so I would suggest that we delete that the transcripts be destroyed when the committee ceases to exist, given the unique nature of this, and holding those documents in trust for future contemplation. And I would also add that the analysts assigned to the committee also have access to in-camera transcripts.
Any comments on that?
But that just
I have a question for clarification, maybe from the clerks. Does this mean that anyone who wants to refer to these documents or consult them, the minutes to our in-camera meetings need to swear an oath?
Is following the provisions of the Act, because anybody who is involved with the committee will have to take the oath. However, the motion also mentions that anybody who has access to the transcripts will also have to have taken the oath of secrecy.
Okay, but and perhaps I misunderstood Mr. Green, but in reference to the value of having these records reviewed in a historical fashion, that would mean that each subsequent person reviewing the documents would require being sworn in with the oath of secrecy. Right. I see. Thank you.
Other comments? So Mr. Green is proposing on this motion that we would eliminate the last clause, which would, therefore, the motion would actually end at subsection 62 sub 3 of the Emergencies Act would then be a period.
The addition of the analysts included as well.
And how would you like the wording for that?
That analysts assigned to the committee also have access to the in-camera transcripts.
Yes, go ahead, please, Mr. Moore.
Are you referring to have access to the transcripts moving forward beyond the ceasing of this committee, or you're talking about as the committee sits, they have access to the in-camera ones from before, because they'd be in an in-camera session anyway, would they not?
clarity from the clerk in that regard?
If I may, normally when we talk about the analysts having access to the in-camera transcripts, it's within the parliamentary session. It's the time during the session. At the end of a session, the committee's director, we don't keep the in-camera transcripts. They're put as part of the wallets that go off to the National Archives. So the analysts would only have access while theoretically the committee still exists in that parliamentary session.
That's practice. That's convention now.
That's the convention now. So, for example, analysts would never have access to in-camera transcripts from a committee from a previous session. They wouldn't be able to.
So then, Mr. Green, I need clarity of what you're referring to by the analysts having a copy of the transcript then as well.
Thank you. I mean, my thoughts around this were that future committees that were dealing with the Emergencies Act, given the sensitive nature, the unique nature of it, would have the ability to retrospectively contemplate what was discussed in camera for the purpose of guiding and providing better procedures and better information on a move forward basis. And so for myself, I don't see the value in us doing this body of work that is really substantive and very unique and precedent setting, to then take some of the information which would be sensitive and again still remain confidential and then destroy it. Whereas I feel like in future occurrences there would be a value, an administrative value, on those with the clearance having access, and that would include analysts, to be able to provide information to future sittings. You know, we have young analysts before us, and hopefully they will never have to be back before us in this way, and hopefully we'll never have to be back before us in this way, but it could happen, and if it does, I feel like starting from where we finish is better than starting from the beginning all over again.
Mr. Motz, I'm wondering if clarity from the clerk would be helpful on this in terms of how this would normally be done.
Thank you. Normally, in-camera transcripts at the end of a session are included, as I said, in the wallets, and they're sent to the National Archives. Under the Memorandum of Understanding between the National Archives and the House of Commons, those documents remain confidential for 30 years. Now, if the committee wishes to investigate perhaps amending that, we can look and see what the possibility is for the committee to perhaps render them publicly available in a shorter period of time. But we'd have to do some research on our side to see if that would possibly contramand a decision of the House. If it does, it could be problematic. That being said, if the committee doesn't want to destroy them, the committee doesn't have to destroy them. They will go into the wallets. Alternatively, this is something the committee doesn't necessarily have to decide now. It can decide as we get into the work more and the committee has a better understanding of the documents they're talking about. At this point, it's difficult for me to say we don't know which documents we're going to be dealing with that might have to be kept secret under the Act versus those that are under the purview of the committee. Thank you.
Just for one point of clarity, in the explanation, I believe I heard the clerk say for public availability, and that's never contemplated in my remarks, that it would never be made public. And I just want to make sure, if maybe I heard incorrectly, but just to make sure for those watching, that it is not the contemplation that people would have access to this in any kind of public way, that they just wouldn't be destroyed, and that they could be referred to from people who swore a secrecy oath under the context of this committee moving forward. Thank you.
Mr. Naqvi?
So thank you. So if I may just suggest, I think what the clerk is informing us in terms of the arrangement that exists between the House of Commons, and I'm assuming it's the same with Senate and the National Library and Archives, is totally appropriate. We should not be looking into changing that memorandum of understanding. I do agree with Mr. Green in terms of not destroying the documents as being stipulated, which I think there's a fair bit of agreement on that. But everything else in terms of the access, we should just leave it as is until they are 30 years later or so being made public as contemplated under the existing protocols. And then, of course, require in between that time anybody who wants to access the documents to take an oath of secrecy as stipulated in the legislation.
Mr. Green?
Thank you. And just to defend my point for being open by default, I would suggest that we do at least entertain and receive back whatever opinion it is in terms of whether or not these remain sealed for 30 years. The spirit of my amendment in this regard is to provide a context for future contemplation. And so to me, it would defeat itself if future MPs and future staff that were working on this, analysts, didn't have access for 30 years. Then at that point, it might not make sense. Oh, we got the analysts with their hands up.
Thank you, Mr. Chair. I just wanted to point out there's the future aspect, but there's also the near future. And perhaps the clerk can correct me if I'm wrong, but the in-camera blues help the analysts quite a bit when we're either preparing a work plan, reviewing evidence, obviously, for reports. So, yeah, there is a thing far down the road, but if the one copy of the transcripts is only available for members of the committee or their staff, then that could potentially make our work difficult. So.
Thank you, Madam Chair. I'm actually glad the analyst mentioned that. I had forgot to mention that earlier, is that one of the advantages of the suggestion of having the analysts have access to the in-camera transcripts is that when drafting reports on behalf of the committee, when preparing briefing notes on behalf of the committee, if they want to access the in-camera discussions that were held by committee members, they do have access to these transcripts. The reason we started, this was relatively in the last few years, we started adding this text into the routine motion, and part of the reason for that is because it greatly helps the analysts do their work, which is on behalf of the committee. So I appreciate the analysts raising that point. That's one of the reasons we add that in, is so that the analysts have the resources to do their work on behalf of the committee.
Mr. Motz, followed by Senator Harder.
Thank you, Madam Chair. In the light of Mr. Green's addition of the analysts, and in your question, Madam Chair, earlier about where would you insert that, may I suggest that it's in that one copy of the transcript of each in-camera meeting be kept with the joint clerks and the analysts for consultation by. And would that work as your addition, Mr. Green? Because it would then include both the joint clerks and the analysts to keep a copy of the transcript.
Perhaps I can go to the clerk for clarity.
I do appreciate what you're saying. We usually have them housed on our servers, and the way that Mr. Green has talked about it, of them having access, allows, instead of them having a copy of it, they simply have access to the servers. Okay. The reason that I think this is the way we prefer to do it is that we retain control of it in our office, which is on our servers, but we now can allow access to them, and then they can readily have access rather than multiple copies being sent around. Thank you. This would be most important.
So I'm wondering, and then for the clerk, if you can tell me if we did that one copy of the transcript of each in-camera meeting be kept with the joint clerks for consultation by members of the committee or by their staff or by the analysts. Would that cover it? And then that puts it in the right context. And Senator Harder.
Madam Chair, I would suggest that we leave the issue that Mr. Green has raised outside of this motion. This motion is for the conduct while we are operating as a committee. But I would also suggest that we instruct the clerks to investigate whether a motion could be considered later to accomplish what Mr. Green has suggested with respect to the work of this committee once it is complete. So I'm in the spirit of transparency, but I don't want to confuse this motion with once we are functus.
Okay, so then between Mr. Fortin.
Madame la Présidente, merci. Ce que je comprends.
Thank you, Madam Chair. And I agree with Senator Harder. I think that it would be wise to eliminate the last two lines of the motion so that the transcriptions would be destroyed. We would eliminate that the transcripts be destroyed, and we would add the mention of the analyst. And then I believe we would have a fulsome motion.
Fortin, thank you. All those in agreement? I'm seeing a lot of nodding around the table. Thank you for that. Motion number 12. It's moved by Mr. Green that the committee publish its public proceedings in both official languages. Is it agreed to adopt the motion? Notice of motion number 13. Do I have a mover for that? Mr. Naqvi? So it is moved by Mr. Naqvi that a 48-hour notice interpreted as 2 nights be required for any substantive motion to be considered by the committee unless a substantive motion relates directly to business that under consideration, provided 1, that the notice be filed with the clerks of the committee no later than 4 p.m. from Monday to Friday. 2, the motion be distributed to members and offices of the whips of each recognized party in the House of Commons and recognized party or parliamentary group in the Senate as both official language by the joint clerks on the same day the said notion was transmitted if it was received no later than the deadline hour. And 3, notices received after the deadline hour or on non-business days be deemed to have been received during the next business day, and that when the committee is traveling on official business, no substantive motion be moved. Is it agreed to adopt the motion? Do I have a mover for motion 14? It's moved by Mr. Green that the joint clerks inform each. Oh, I'm sorry, Mr. Brock. Are you on 14?
On 14.
Okay.
And I don't know if this is the subject of friendly amendment or whether this can be dealt with at a later occasion, but my experience has shown that far too many times committees had been delayed as a result of connectivity issues. So can we ensure that whoever is arranging the connectivity tests, that so much time be allowed in advance of a start time to deal with those technical issues so that we're not wasting precious time during the start of a session?
Turn to the clerk.
Thank you, Madam Chair and Mr. Brock, for your comment. So what this motion insists is that we inform as the joint clerks, we inform each witness who's going to appear before the committee that technical tests have to be done before a witness appears. This is done regularly with all witnesses, and they're not done immediately before the meeting begins. They're actually done in some cases several days in advance so that we can try and allow our technical team to troubleshoot issues. We also make sure to try and send, whenever possible, a headset so that the appropriate headset is used by the witnesses when giving testimony. Where we have faced cases in the past, and I have seen it even as recently as the last few weeks, we'll have a witness that tests everything, their equipment all works, and for some reason there's a technical problem at the meeting itself. We do a sound test when they sign on to make sure that their sound is sufficient. There are, however, I caution all members of the committee, there are always instances where, despite all of the work that we do, we still continue to have technical issues. But that being said, this motion was set up so that we can also put pressure on witnesses to make sure that they do that technical testing. And I have to say the vast majority of witnesses are quite happy to do that technical testing, and in many cases it has avoided problems. That being said, I do caution all members that we can't offer a 100% guarantee that we're not going to have technical issues. We do everything we can, and that's part of what this motion was set up for, was to add pressure to witnesses that we really do need to do these tests before the meeting itself. Thank you.
Mr. Brock, does that require an amendment, or are you satisfied?
I am satisfied with that explanation. Thank you.
I think we share your concerns. It indicated by the clerk best intentions.
Madame la Présidente.
We'll do the best we can. Mr. Fortin?
Oui. Je crois pas avoir.
I don't believe that in the routine rules that mention has been made of the obligation or not of witnesses appearing in person, and where we're talking about the problems concerning technical issues, and we've all seen this. We've had testimonies that were hard to hear. Interpreters could not perform their work because they were not using adequate equipment or the Wi-Fi was not adequate. So would it not be wise to plan for, in our rules, a distinct paragraph to the effect that witnesses that have an office on the Hill, because we may very well hear from members of Parliament and their staff, and those people who have an office on the Hill would be mandated to appear in person rather than virtually. So I don't know. I'm just asking the question, would this be a good idea to plan for?
Yes, merci beaucoup, Madame.
Yes, thank you, Madam Chair. And just to explain to everyone on the committee, on December 7th, the House of Commons adopted a motion covering House of Commons committees. And this allows certain witnesses to appear in person. The original order adopted by the House at the beginning of this Parliament indicated that all witnesses must appear virtually only. But another motion was adopted, and I can read it, adopted on December 7th, saying that notwithstanding any section of regulation, special order, or use, all members of Parliament, senators, department staff, and parliamentary staff who are appearing as witnesses before a permanent joint committee, a special committee, or a legislative committee should do so in person.
Certain witnesses to appear in person, but it limits which witnesses can appear in person. This rule was adopted specifically in the context of House committees. It does mention special committees and standing joint committees. It'll be up to the committee to decide if the committee feels that this, to my mind, this should also allow the committee, this committee, to have certain witnesses in person. However, I should say that the caveat with this motion is that only certain witnesses can appear in person. Comme on dit, c'était les députés.
It does mention that it is members of Parliament, senators, department staff, and parliamentary staff have the right to appear in person. All other witnesses must appear virtually. And I don't know if this helps with understanding Mr. Fortin, but I can let you know that even staff that have offices on the Hill can have technical issues, and that is even after their equipment has been tested. So I don't know if amending the motion would help to clarify the issue. Thank you. So if I understand you correctly, witnesses that you're mentioning, and it's ministers and staff and so on, have the right to appear in person. What I would propose, or at least suggest, is could this not say they must rather than they can appear in person? And maybe we can't. You do raise an important point as far as House motions. If we cannot demand in-person appearance, can we not at least ask these people who can appear in person, ask them to make the effort, to make a greater effort to be here in person in order to make the interpreters' work easier and make the whole of the committee's work easier by avoiding these delays and connectivity issues. So I'm glad that you're raising the question of whether they should or they can. The motion adopted by the House states it is up to the witnesses to decide. It does not give the committee that right, but of course the committee can ask that if they are entitled to appear in person, the committee can certainly strongly suggest that these witnesses appear in person in order to facilitate their appearance. The committee can always adopt a certain language to that effect because the committee cannot force them to appear in person, but they can strongly suggest that they do so.
Merci.
Mr. Fortin, I'm wondering whether the motion as it currently reads could stand on its own, and then when we get two witnesses, we can deal with that request on behalf of the committee. Would that satisfy?
En fait, ce que je suggérais, Madame la Présidente.
In fact, what I would suggest, Madam Chair, is that we add something to Motion 14. We could add a paragraph right after what is there currently to say something along the lines of witnesses that have an office on the House of Commons. There is an enumeration there. I don't remember it by heart, but we could take that list and say that these witnesses who have an office on the Hill. My first suggestion is to make it mandatory to testify in person. However, if we cannot force them to do so, then yes, I think our position should be that to strongly urge them, to ask them to deploy additional efforts to be here in person. It could simply be an additional paragraph. I can put something in writing if you want. What I wanted was to hear other members of this committee speak on this issue. I think that we're all worried by this type of situation. We see this regularly in our committees, and now we are here with a special joint committee. We're moving ahead in foreign territory, if you will, so it's a little delicate for us. So if we could remove any extra obstacle, I think that would facilitate our work. Perhaps, I don't know. I don't know if it worries others as much as it does me. What do other members of the committee think?
Mr. Motz?
Thank you, Madam Chair. I would tend to agree with Mr. Fortin. I think it's incumbent. It would be a word that I would use on members like the motions in the House read, members, senators, and departmental and parliamentary officials. There shouldn't be an option of whether they appear virtually. It should not be an option, especially at this committee. And I know the motion says may. I think, quite honestly, we as a committee might be able to put a bit more emphasis on should or must. This is a serious. The responsibilities of this committee are very, very serious, and we all recognize that. And I think having someone in person, to me, from my background, I want to see them. I want to see how they answer. I want to see their body language. I want to see all that sort of stuff because I know whether or not they're giving me a load of BS or not. And that makes a big difference in person. And I can't see that in virtual. And as much as possible, even non-parliamentary staff and senators and members, I would encourage us to invite in person, if possible, Mr. Clerk, if possible, to have them here in person, as much as it's reasonably possible to do.
Okay, Mr. Naqvi, and then I'll ask Mr. Brock, and then I'll ask the clerk to respond. Mr. Naqvi.
Thank you, Madam Chair, and I respect the points that my colleagues are raising, but I will also respectfully disagree with them on two grounds. One, as the clerk mentioned, there is a motion approved by the House as to the hybrid nature of the Parliament till June 23rd, and we are obligated to live by that motion that dictates how this Parliament is going to function until that time. Secondly, I do want to remind the members that we're still in a global pandemic. The pandemic is not over yet. I'm concerned about people's personal health and to what extent they feel comfortable being present here in person versus appearing in a hybrid fashion. And so I think, given the times that we are living in, we should pay due consideration to their views. If the committee feels that when they're being invited, a line may be added that if they feel comfortable to come in person, that they will be most welcomed to do so. I think we have seen of late many ministers are making the effort to come in person themselves, but requiring them by way of a motion of this committee not only contravenes the House motion, but also puts us in a difficult position from a public health perspective that we should be mindful of. Thank you.
Thank you. Mr. Brock, and then I see Senator Carignan has his hand up. He'll be next. Mr. Brock.
I can't underscore the importance of the words of my colleague, Mr. Motz. There is no substitute, in my view, and this is to all the lawyers that are on this committee, particularly to my colleague, Mr. Varani, who worked for the Ontario Public Service as a Crown Attorney. There's no substitute in terms of questioning someone in person. I'm mindful of the House order. I'm also mindful of the fact that we can't force anybody to attend in light of that order, but we can use words such as strongly encourage, strongly recommend, make every effort to wherever possible. And to the extent that some ministers have already appeared in person on the Public Safety Committee in the last couple of weeks. I know Minister of Public Safety, Mr. Mendocino, has done that on numerous occasions. So it is within the purview of this committee to make that type of language possible, and I would encourage that wherever possible.
Thank you, Mr. Brock. Senator Carignan.
In fact, I was going to say the same as my colleagues did. We cannot require it of them. However, we can strongly urge them to appear in person, and I think that that's what we should do, given the importance of reading the nonverbal body language of witnesses. I think it would be appropriate to do that.
Senator Harder.
Simplement, je suis d'accord avec mon collègue.
I'd simply like to say that I agree with my colleague, Senator Carignan.
Clerk, do you have comments on that?
Just to say that unfortunately the order of the House applies to the committee. The committee can't overturn an order of the House, certainly, though I certainly appreciate the comments made by all members about the value of having witnesses in person. What I might suggest as a possible amendment or possible text that could be added in would be something similar to this. I drafted a little bit in French. I'll read it. At the end of the motion, adding in, et que le comité recommande
that the committee strongly recommend that witnesses that can appear in person, with regard to the motion adopted on September 7th in the House, consider to do so.
Written or writing in French, but something to that effect, which I guess a loose translation in English would be, and that the committee strongly recommend that the witnesses who are able to appear in person pursuant to the order adopted by the House of Commons on the 7th of December consider doing so. That is just text that I've put out. I don't know if members are happy with that or not. Or
Mr. Varani had his hand up.
Madam Chair, my hand is raised, Madam Chair.
Yes, go ahead.
Thank you very much. I just want to return to the statements that were made by Yasser Naqvi and the most recent statement that was just made by the clerk. I mean, we have a motion that's been passed with respect to hybrid parliament. We have a statement that has been endorsed by Parliament itself, by the House of Commons, that relates to the hybrid nature of the sittings, and why perhaps that may not be convenient for the way that this process rolls out for this committee. That is where we're at. And it's not because we are at this junction because of any political or ideological imperative. It's based on the public health nature of the fact that the global pandemic is still with us, as Mr. Naqvi rightfully pointed out. And I guess I'm just a bit puzzled by the concern that is being voiced by members of this committee with respect to in-person attendance because of the feeling the need to alter what is language that's been used at many committees, because the track record is that witnesses, including government witnesses, including government ministers, I think there are at least 4 or 5 in the last few weeks that have appeared in person. Everyone is trying to do that whenever it's possible. So that's already the status quo. So changing the status quo to address a concern that actually isn't present, to my mind, is illogical at this point, because what we're doing is following something that's been enacted by Parliament that relates to every single committee. Trying to wordsmith it at the 11th hour with language at this point does not, to my mind, seem like an efficient use of this committee's resources. Thank you, Madam Chair.
Thank you, Mr. Varani. Then to Mr. Green, followed by Mr. Motz, and then Mr. Brock.
Thank you. I've been listening intently to positions that have been put forward by all sides, and I would have to defer to my policy of what's good for the goose. And I think that there could be a scenario where any of us at any given time, including today, would have to rely on being in a hybrid format. And I would suggest that the same principles that we would, in courtesies that we would extend to ourselves as committee members, we would extend to witnesses, notwithstanding the importance of having people in person. I just want to say that I would agree that there is an element that I'm recapturing today that I've missed in other meetings, but it's also not lost on me that we have two members of this committee logging on in a hybrid format, which is good, and I think it is something that we may have to rely on in different places throughout this process, understanding that some of us are coming from a little bit further away. And given the uncertain nature of our own planning and scheduling, it may be required that each of us at any given time may have to do that. And if we have the ability to do that, I think it would be fair and consistent to ensure that that's extended to the witnesses. And I just wanted to say that, that wasn't lost on me throughout this discussion. Thank you.
Thank you. Mr. Motz, before I go to you, I'm just checking with Senator Carignan. Is your hand still up or do you want on the list?
Oui, non, c'est
No, it's a new hand, if you will. I simply want us to make a distinction here. It is important to be able to appear in a hybrid fashion. I'm joining you virtually right now, but it is different for a member of the committee and for the witness, because a witness, well, we need to verify their credibility. If they are in their office, somebody could be there to pass a note to them, to give them different lines, to help them answer, and that's not the case when the witness is here in person. So when we want to evaluate a witness's credibility, well, it is preferable for them to appear in person. Once again, I think I know that we have to respect what was adopted in the House of Commons. But I think we should still invite witnesses to privilege the in-person approach.
Followed by Mr. Brock.
Thank you, Madam Chair. In light of the conversations, I think it's important to recognize. I mean, I know that the House order requires witnesses, non-official witnesses, to appear virtually. However, we also know that the Board of Internal Economy has made a decision to allow spectators in committees after Easter, and that House order may very well, be relaxed with respect to other witnesses. So we need to keep that in mind and be flexible to that whole concept that there may be a relaxation of the requirement to be here as much as possible.
Mr. Brock.
Chair, I just want to go back to square one. We've had so much debate, so much discussion. I don't know what the actual wording is that you will ultimately seek an agreement on, whether it's the original wording or the wording as amended by our clerk. If we can get some clarity on that, because I'm just forecasting a situation that if it's in relation to the amendment, friendly amendment as proposed by the clerk, you may not get full unanimity agreement across this committee. We may have to turn to a vote.
Thank you very much. Then I'll go to the clerk. I just asked you to repeat it.
Yeah, I can repeat it. And thank you to my learned colleague who pointed out I had the wrong date of the order adopted. My apologies. But the amendment roughly would be in French. Et que le comité...
And that the committee strongly recommend that witnesses that can appear in person with respect to the order adopted on March 2nd, 2022, be encouraged to do so.
Which would be in that the committee strongly recommend that witnesses who can appear in person pursuant to the order adopted by the House of Commons on the 2nd of March 2022 be encouraged to do so. But that being said, this is just text I'm throwing out. I can't move amendments, so it's just
I understand.
That was actually the point that I was going to raise, is that it was a suggestion. It hasn't been duly put.
Would you like to move it?
Not necessarily. I was just.
Je la propose alors.
I'd like to move it then.
So it is moved by Mr. Green, and we heard.
I could. I
sorry,
just observed
Mr.
it. I did not
Fortin,
move it.
Pardon me.
Le sénateur Carignan a dit qu'il souhaitait la proposer, donc.
Senator Carignan said he wanted to move it, and I would agree.
Are you prepared to move it?
Oui, je propose.
Yes. Yes, I motion it.
Thank you, Senator. Senator Carignan, and I'd ask the clerk just to read it again.
Thank you, Madam Chair. And that the committee strongly recommend that witnesses who can appear in person pursuant to the order adopted by the House of Commons on the 2nd of March 2022 be encouraged to do so. Et que le comité
And that the committee strongly recommend that witnesses that can appear in person pursuant to the order adopted by the House on March 2nd, 2022 be encouraged to do so.
I think we should go on division.
I think we have to call a vote on this.
Mark, help me do that. I haven't done it hybrid yet. Okay, go ahead.
We'll call a nominal vote on the adding the amendment at the end, and I will start as joint clerk on the Senate side. I will start the way we will proceed is I will start with the senators, beginning with the Senate chair, and then my colleague will continue with the members of Parliament. So on the motion and amendment, the Honourable Senator Boniface.
Yes.
L'Honorable Sénatrice Boniface vote oui. L'Honorable Senator Carignan CP.
Oui.
The Honourable Senator Carignan votes yes. L'Honorable Senator Harder CP.
Yes.
The Honourable Senator Harder votes yes.
I will now proceed with the vote on the House of Commons side. For the benefit of members, I will start by asking the chairs to vote, and then I will proceed with the rest of the members. Monsieur Fortin?
Oui.
Mr. Green?
Je vote contre.
Ms. Van Duyen?
Je vote contre.
Mr. Naxi?
I vote no.
Mr. Varani?
I vote no.
Mr. Brock?
Oui.
Mr. Motz?
Yes.
Yeas, pour 6, nays, contre 4.
Pardon? The motion is amended. Thank you. Okay, number 15. Do I have a mover for motion 15? Moved by Ms. Van Duyen, that all documents submitted for committee business.
I don't think.
We have to put the question.
Pardon me, committee members. We've adopted the amendment. Now we put it to the motion as amended. Do we have an agreement? Okay. Thank you. Thank you for your patience. Okay, we will move to motion 15. It was moved by Ms. Madayan that all documents submitted for committee business that do not come from a federal department, members, or senator's office, or that have not been translated by the Translation Bureau be sent for prior linguistic review by the Translation Bureau before being distributed to members. Is it agreed to adopt the motion?
Agreed.
Thank you. Motion number 16.
Madam Chair?
Yes.
It might be a small, minor thing, but we may want to add that
With number 16?
16, correct. We may want to add that the interim budget of $50,000 be adopted and sent to the Board of Internal Economy of the HOC for approval. We may want to add for approval. Might just be a minor thing, but.
C'était déjà prévu dans la version.
That was already included in the French version, so of course I would agree with my colleague. It's just a question of making both sides match.
I appreciate that 50,000 is kind of the standard committee budget. But should the committee retain legal counsel, we may need to adjust this, or am I under the understanding that that would be a separate budget line, separate from this 50,000? Very good. Thank you.
For those on the screen, I'm seeing that's correct. Okay, so there's Mr. Green raised the question, so of adding for approval just for clarity and to bring it in line with the French version as well. So it's moved by Mr. Green that an interim budget of 50,000 be adopted and sent to the Board of Internal Economy of the House of Commons for approval. Do I have agreement? Okay, that ends the motions that have been tabled so far. Mr. Motz.
Is this where committee members can introduce additional motions that we want considered?
Do that now.
Okay. I would propose, and if I could get someone to hand these out for me, please. I would propose the following motion, that during questioning of witnesses at all future hearings, the chair of the committee.
Point of order, Madam
Chair.
Sorry. I do apologize, Mr. Motz.
I'm sorry.
I was just wondering if, in the order of things, if a committee member, I see my colleague Mr. Arif's hand was up. If a committee member had a routine motion, should we go to complete the routine motions first, Madam Chair, or should we move on to this motion?
I believe this is a motion.
This is a routine for me.
Okay.
Well, it's not routine. Yeah. Sorry, Madam Chair.
And that there are, Mr. Motz is introducing a routine motion.
Madam Chair, just my hand has been raised. I'm not sure who was first in the order of precedence, but mine is fairly routine and probably is going to engender less debate than Mr. Motz's. So I'm in everyone's hands. I think the clerk has been provided a copy of the text of what I and some other Liberals are proposing.
Would you be agreeable to let Mr. Brownie go first?
Anything for a riff, absolutely.
Okay.
It's on the record. It's on the record,
do we have that distributed, Mr. Brownie?
It was sent by one of our staff to the clerk, and it's marked additional routine motions 1 and 2. So, Mr. Clerk, can you just confirm you received it? I think it was Ms. Bendayan's staff that had sent it to you.
Yes, thank you, Madam Chair. Yes, we did receive that document, and if you consent, we can distribute that document to the members of the committee now electronically, which is what I will do in a moment. Thank you.
Thank you very much.
Spend for just 5 minutes while he does that?
Sure. Thank you.
Thank you.
Gotta get the gavel.
Mr. Motz, I understand.
Yes, Chair, Madam Chair, if I could, I'd like to raise a point of order based on my generosity to Mr. Varani. My routine motion was actually ready to roll in both official languages, and we've had to endure a long recess from this committee in order for Mr. Varani to go forward. But I hope he recognizes my generosity in this and will endeavor to extend me some grace at point down the road that I'm sure I'll need.
Mr. Varani, the floor is yours.
Any man with a purple tie on gets my vote of confidence there. So yes, Glenn, I absolutely understood it. Thank you for your generosity. I'll try and be very, very brief, Madam Chair. The document hopefully has been distributed to all members at this point. The routine motion, just paragraphs 1 and 2, which is what I will speak to, just calls for some basic additions, which is that the first paragraph says that each 2-hour meeting in which witnesses are called be limited to one witness panel of up to 4 to 5 witnesses, so as to allow the opportunity for a fulsome or comprehensive question period. And this is to avoid a situation where we've got such a distribution amongst the questioning, et cetera, among the various senators and members, that we have a time to sort of probe the issues and give them the consideration that they deserve, which with each set of witnesses. Trying to jam in multiple sets of witnesses within a 2-hour window is probably unlikely to be efficient. The second suggestion, Madam Chair, is that the clerk and analysts be instructed to compose balanced witness panels whenever possible, such that each witness appearing on a panel must have been requested by a different party or senator, save and except for situations where all members agree that a particular witness or witnesses should appear. So speaking to the latter part of paragraph 2, there's going to be, I think, very little contention that ministers, entities like the RCMP, law enforcement should be coming. That's one where I presume we'll find a strong consensus. In other situations, less so. And again, this is meant to be a direction, but not a firm obligation on the part of the clerks and analysts. So the words "whenever possible" are injected there to try and provide some balance to the types of panels we're hearing, so we're not getting all of one side of a particular story or particular vantage point in any given meeting. Thank you very much, Madam Speaker. I'll end it there.
Thank
Madam
you.
Chair, thank you.
The motion is so moved. Mr. Brock?
Thank you, Madam Chair. I think my colleague, Mr. Varani, had sent each member a copy of this document to our P9 accounts. But for some reason, it did not go to my account, so I've not had a chance to read this. So I'm just wondering if Mr. Varani or a member of his staff can ensure that I receive this.
I believe it was sent by Ms. Bendayan's staff to the clerk, Mr. Brock, and the clerk is the one who's distributed it to
Your P9, Mr. Brock?
Mr. Brock, I had to refresh my phone to get it, so I'm wondering if that's part of the problem. Mr. Mott, you have questions or?
Yes, questions in regards to the routine motion. Number one, that each 2-hour meeting in which witnesses are called be limited to one witness panel of up to 4 to 5 witnesses, so as to allow the opportunity for a fulsome question period. I agree that that we need to allow for fulsome question period, but I'm wondering whether we should consider limiting the number of witnesses per each panel to 2, and in the right circumstance, maybe 3. To me, it would allow all of us on this committee to be able to have a fulsome round of questions on that. I don't think there's any time limit on our committee. And I think there's already been some understanding that we want a fulsome, transparent process here. In order to do that, we've all been in committees where we have so many witnesses that appear that we can't get through them, and we can't get through their testimony well, and we can't get through asking the questions we want, and not everybody on the committee can ask questions. So I would encourage us. I like the idea, but let's limit that to 2. Possibly 3 witnesses per 2-hour panel, please.
Thank you. I just want to reflect on our earlier amendments to the routine motions that basically set the agenda-making process open to the entire committee. I have had the privilege of reaching out to every member of this committee, and in those conversations discussed, at least from my perspective, and I know that I've had discussions with the other co-chairs, about really being intentional about setting our work plan early and having an emphasis on perhaps the next 2 or 3 meetings being with the specificity of the work plan. In reviewing the motions that have been sent out today, recognizing where we're at in the time in this meeting, I would just wonder if maybe what we did is come to a consensus that we will concentrate the next 2 meetings for sure on setting forth the work plan where we can get into witnesses and agenda items. But the fact that we've already contemplated the agenda items as being open to the committee as a whole would suggest that we could address the first 2 routine motions that have been put forward by Mr. Varani. And I would even go further to suggest that the other new motions that have been presented, while understanding that they're in order, this is the appropriate time to do it, that it might be better situated for us to take the advantage of having constituted this committee, done the administrative processes that were already agreed upon in advance, rather than trying to embark on this whole new subset of administrative questions, which may be better situated in a next meeting that strictly deals with the work plan. So I don't know what the intention is in terms of how long people want to debate this long list of new and additional motions, but it has generally been my experience that routine motions are things that have had prior discussion amongst the different parties to come to some kind of consensus so you can routinely move through them. And so I would just put through you, Madam Chair, to the movers of these motions, both Mr. Varani and Mr. Motts, if it might make sense for the good and welfare of making it through this first meeting to commit to addressing these in a deeper way so we don't feel rushed by time, we don't feel squeezed by interpretation, to deal with these in the next first available sitting of this meeting.
Okay, Mr. Fortin.
Merci, Madame la Présidente.
Thank you, Madam Chair. I quite agree to say that it's perhaps a bit early to establish a list of witnesses. Moreover, the motions that Mr. Varani is proposing, motion 1 and 2, I don't know, because routine motions are rules that we give ourselves, rules that apply to all of the witnesses, all of the proceedings of the committee. But we know that in certain cases, I'm sure we'll all agree to say that 2 minutes will suffice, and in other cases, we might all agree to say we need a full day. So I don't know, really, I think I'd feel uncomfortable today to decide specifically on the number of witnesses that we will invite without knowing who we're talking about. I think that we should today just focus on general rules, and when we look at the list of witnesses that we wish to invite, then at that moment, it's not a bad idea, Mr. Varani. I agree that we should say, okay, if we're going to invite so-and-so, could we not limit ourselves to 2 or 3 witnesses on this day and perhaps give them so many minutes each and perhaps group them like this or like that? We don't know if we're discussing a particular theme or subject. We might want to hear witnesses independently of who has assigned the witnesses. So I think it's a bit too early to decide on the specifics right now, and it's a bit uncomfortable for us to determine this, to discuss these issues, where we'll probably want to adjust depending on the witnesses.
On the list, then Mr. Green, then Mr. Motts. Mr. Varani, go ahead.
Madam Chair, I believe that was my hand from earlier. I apologize, so I'll drop it, but I appreciate the ability to respond in total to once everyone has made their submissions.
Thank you, and we will do that. Mr. Green.
Yes, just again contemplating the time and knowing that part of our legislative requirements will be to agree, hopefully, on an interim report that would go back to the House. And so I would just remind members that at sometime this meeting, we would probably like to entertain what that might look like. And so just as we get into this debate, to make sure that we set aside that time at the end for that interim meeting to be reported back to the House that we've constituted this committee and that we're meeting our legislative requirements.
Okay, before I move to Mr. Motz, just to be clear that there has been a request to extend, but obviously we can't extend very long. So, Mr. Motz, I'll go to you.
Thank you very much, Madam Chair. I would agree with Mr. Fortin. The idea of witnesses lists now may be a bit premature, and we should maybe consider finishing routine. I don't know whether. I guess number one is kind of a routine focused. I know that I feel my motion that I was presented is a routine matter that could be dealt with quickly today. And I don't know, Mr. Green, you indicated that maybe 1 and 2 are not routine and should be moved till next time. Is that what you're saying?
I was just suggesting that for the purpose of our constraints, that we set aside the next 2 meetings to do this type of work, in that I don't believe that any of the parties have been consulted to get to some kind of consensus. So it would have saved us time for a more substantive debate if we held it off until the next meeting and the meeting after that. It's the will of the committee, of course, if the committee would like to delve into that. I just want to make sure that we hold time aside within the remaining minutes, I'm not sure how long we're going to be extended for, so that we could hopefully get a consensus around what has been agreed upon in this initial constituting meeting to send back to the House as part of our first interim report back to the House. So before we go down the rabbit hole of debating these motions, I just want to make sure we hold fast to that time.
Okay, and I think we're back to Mr. Varani. I'm not seeing anyone else around the table. Go ahead, sir.
Thank you very much, Ms. Boniface. I intentionally didn't raise my hand because I didn't want the plant interfering with you again. With respect to what I just gently point out is that obviously I guess we'll have some differences of opinion as to what's routine versus what is not. I think to my mindset and to some of my Liberal colleagues, we did think that these were fairly uncontroversial. I would just respectfully point out to Mr. Motz, and again, thank you for letting me address this now, is that if we're going with only one panel, then having only 2 witnesses for a 2-hour meeting, I think would be not an efficient usage of our time. So that's why I was contemplating 4 or 5 witnesses for the full 2 hours, which is roughly 2 per hour. I think that's well within what committees are capable of, this committee and other committees. And I would just gently push back on this idea that we do have resource limitations for this committee and for any committee, and those may be exacerbated by things that are being suggested, including the retainer of potentially outside counsel, and that there is a benefit to Canadians, if not to this Parliament, or to both, in respect of ensuring that we do a thorough work as a committee, but also that it is timely. We do know that there is no time limit that's prescribed within the statute or within the motion that created this committee, but this committee's work is also commencing now. Within 60 days, an inquiry will commence. That formal inquiry must report back within 1 year of the invocation of the declaration, etc. So there are notional time parameters to the work that we're doing, and I think it's incumbent upon all of us to respect those time parameters for the benefit of all Canadians, so that they understand an invocation was made of a declaration of emergency, and that the study is being done, and it's being done thoroughly, but in a timely basis. But I will defer to the hands of the committee members on the ultimate question that Mr. Green has put forward as to whether we should just defer this for a later date, because I am conscious, as he rightfully points out, that there is the matter of reporting within 7 sitting days pursuant to, I forget the clause, it's around section 62 or 63 of the statute. This committee must make some type of report back to Parliament, I believe, next Tuesday. So perhaps that should be addressed immediately. I'll leave it at that. Thank you, Madam Chair.
Mr. Naqvi and then Senator Harder.
Thank you, Madam Chair. It's as if Mr. Rani has insight into my mind, because he pretty much used exactly the same words I was going to just use, which is just to be cautious that we do not notionally have unlimited time, and that we be mindful of the responsibility that has been given to us under the statute. And there are 2 different processes, and there are different language that has been used in the legislation that gives us guidance as to the scope of the work we have to do and the timeliness. And the way I see it, that this is more an oversight process that we'll be engaging in. The other point I just want to caution, and I heard Mr. Green use this term twice now, which is interim report. Let's not add things that we don't see in the statute. Statute speaks of a report, so let's not start giving labels to things that may not exist, because that will just get us off track, if I may say so. So I just want to make sure that we try to focus on the statutory language and the mandate that has been given, and there are some timelines embedded in that document. Thank you.
Thank you. Senator Harder?
Yeah, very quickly. I think Matthew Green has given us some good advice. I think we are now getting into that which we would have had our procedure and agenda committee deal with, and I think that should be the subject of the next meeting. What we might want to conclude today is that part of what we must report to comply with the order that has been given, which is what has to be tabled next Tuesday. And I think we've done a good job thus far in terms of the interim of that report and the motions that we've already passed. If there are other routine motions that we could deal with in short order, fine. But we only have limited time today. I do agree that we have to indicate that we're making progress quickly, but the best way of doing that is to actually develop a work plan and get the work plan adopted so that people can see that we're being deliberative as well as expeditious. So I would suggest that we finish today in the spirit of the motions that we've already adopted, others if necessary that are routine, and have an agenda that is more procedural and scheduling as soon as possible.
Madam?
Thank you, Madam Chair. It sounds to me like there's some consensus around the table. I wonder if I could ask the clerks to let us know what might be included in the report that we are contemplating.
We would obviously set it as a priority, and we'll ask the clerk to look at the anticipated interim report that will be required to be tabled, I understand, in the House on Tuesday and in the Senate on Wednesday.
Thank you, Madam Chair. The analysts have prepared a brief draft report, which I have just sent by email to all members. Hopefully all members will receive it electronically and be able to look at the text that's in it. And then the analysts can speak to it as necessary. Thank you.
Oui, je ne sais pas si c'est possible de demander.
Would it be possible to ask a question of the clerk just to clarify the text a little bit that was just sent? I see that there's reference to an organizational meeting held today, March 14th. This is the meeting. This is not an organization meeting. I wonder, is there a difference between meeting and organization meeting? Well, put simply, the organization meeting is the first meeting where the committee starts its work. An organization meeting only has one thing on the agenda, the election of chairs, because without the election of chairs, the committee is not constituted yet. So that is why we call them organization meetings, because it is not a meeting per se. It is a meeting through which we elect chairs, and that allows the committee to continue its work. Thank you.
the report?
Madam Chair, I understand the explanation now, but I would still like to propose that we use the term a first meeting.
I'm not seeing anybody disagree with first meeting. Is that agreement? So instead of held its organization meeting, it would say held its first meeting. I think we're seeing agreement around the table.
Thumbs up on the screen.
And thumbs up on the screen. Thank you very much.
Just happy to move the report as amended.
All in agreement? Agreed. Excellent. Thank you. Yes, Mr. Motz.
I'd like to go back to some comments from Mr. Varani and I think some of my Liberal colleagues. I have to agree that I think items 1 and 2, as Mr. Varani sent, and my motion as well, my first motion, are routine matters that could be dealt with today. We've already dealt with the report. I don't know how much time we have, Mr. Clerk, before we have to be gone. But if we've got 10, 15 minutes, we can deal with them, then they're out of our way, and then we can get on to more substantive stuff the next time we meet, whenever that is. And I suppose that's another issue that we have to deal with as well. When is that going to be and where? Just my observation, I might be out of line, but I think that they fall within the category of routine motions.
Just so the committee.
That one, Mr. Motz?
That one. Yes, Mr. Fortin, the one, and as well as 1 and 2 of Mr. Varani's, I think could also be categorized there, unless I'm missing something. Number 1 for sure.
Yeah, this is, again, a past reference to the routine motions that we deleted that would have constituted an agenda meeting. It feels like to me these two motions, 1 and 2, would have been appropriate had we not disregarded the kind of subcommittee nature of the agenda and process committee. We're now contemplating this as a whole, and I believe my friend Mr. Fortin raised an important point, which is that if we're overly prescriptive without first contemplating the work plan, there may be scenarios where some people would require a greater scrutiny, and there may be situations where having a panel that's more varied might be better. And so my caution is one of being overly prescriptive before we've contemplated the work plan, and given that we're already going to be deciding on this on a case-by-case basis in terms of who our witness selection is, it's going to be agreed on by consensus anyways. So it seems to be moot at this point.
A lot of nodding. I'm wondering if we would be best to reflect on this and we could deal with it as a priority and either move ahead with the motions at the next meeting, or once you've had a chance to reflect on it, then we deal with it as time permits as we move along. Does that sound more agreeable to everyone? Okay, I'm hearing agreement. Mr. Clerk, are there other matters?
I'm not aware of any other matters that have to be raised at the committee at this time. Thank you.
Mr. Motz.
So the motion that I distributed, or the about legal counsel, is that something that will be then discussed at the next meeting as well? Very good. Thank you.
Just for clarity, since Mr. Motz, you also raised the issue on when we would meet again. We don't have a date at this point. We checked with the clerk earlier, and that will be circulated as soon as we get clarity from the leadership. Mr. Brock.
On that question, I know that I can't speak on behalf of everyone on this committee, but certainly my colleague, Mr. Motz, and I, we came to Ottawa. We changed our vacation plans, our March break plans. We came here to work. I'm prepared to sit this week if necessary. In between sessions, in between our non-sitting weeks, I'm prepared to sit. I'm listening to what my Liberal colleagues have indicated, that we don't have an unlimited amount of time, but we need to prioritize this committee and take it as seriously as we can. And I think it would be remiss if we did not take this opportunity with the time that we have to actually schedule, at the very least, our next meeting, as opposed to waiting from some input from the House Leader's Office. Why can't we deal with that today?
I don't disagree. I think our issue is trying to fit within the agenda of availability of staff and such like. So we anticipate we will meet next week. I just can't give you a date and time at the moment. Am I correct, Mr. Clark?
Yeah, thank you, Madam Chair. My understanding is the matter of when the committee will sit next has been raised at the level of the whips. I have not heard any news as to any decision taken by the whips. So I know the whips of the House of Commons are discussing the matter. They will then speak with their counterparts in the Senate. And when there's an agreement as to when to sit next, they will inform me and we will inform the chairs. That's my understanding of where the discussions are at this time. Thank you.
Well, thank you for I think we share your concerns in terms of ensuring that the committee moves along. So thank you for that. Mr. Motz?
I'd like just to add one more thing. Like Mr. Brock said, and I'm sure all of us on this committee, we're here to work. But for me to get here, it takes me a day, right? So, and I just can't do it on a whim because we know that flights are not what they used to be. So I would, some flexibility there, like just a drop of a hat meeting tomorrow may not work for me. I might get here just as you guys are wrapping up, which is probably good for you guys, but not necessarily for me. But just keep that in mind when we have these conversations, having some dialogue ahead of time to set some days in advance where we can all get our calendars together and try to do a survey monkey of what days work the best sort of thing. Those, I think, work really, really well, and we can try something.
We're all of the same view. We're trying to get some standard timing, and as standard timing fits would then give you significant notice in advance of what that would standard be.
Thank you, Madam Chair. I just wanted to express my agreement with my colleagues opposite. We have all made extraordinary sacrifice to make this a priority in our work. I know that I was very glad to make the trip to Ottawa to be here in person, and I think everybody around the table is in agreement that this the work that this committee is about to undertake is absolutely critical and actually historical. So I encourage the whips to continue discussions so that we may meet quickly but also regularly. Thank you.
Thank you. Mr. Naqvi, did you have something to add?
Absolutely, and that's in the spirit of getting down to work. Madam Chair, I was wondering if I can make a request of the analysts that they provide a copy of all debates and committee proceedings from both House of Commons and the Senate from when the Emergencies Act was debated in 1987.
The analysts?
Thank you.
And the other request, if I may, as chair, say that I had made a request as well, or discussed with my colleagues, perhaps looking at the Hansards from the initial debate on this issue back in the establishment of the Act, and wondering if the analysts could also bring that forward for all members to have a chance to look at. Mr. Green, and then Mr. Motz.
So on that, with the briefing, and given the nature of debates, I know that we did have legal counsel present, and I'm wondering if, for the good and welfare of this committee, that any type of definitions of terms or interpretations of terms as been defined within the legislation or contemplated also be added in the briefing note. And I say that because, as was referenced earlier, we want to make sure that we're debating from the same set of terms and definitions and understanding. And I would say that, in my initial glance of the legislation, what I found to be is some significant cases of ambiguity, and where ambiguity is legislated, it is often to be taken as at least to my understanding, to have a liberal interpretation. And so any kind of direction that I could receive or the committee could receive on small L liberal, very small, very small. Yes, wide application, I think, would be a more appropriate nonpartisan term, but I thank my honorable colleague for that. So in addition to any briefing notes, if any types of definitions of terms could be added to help us give an overarching common space of debate, that would be helpful as well. Thank you.
And Mr. Motz? Oh, pardon me. I'll just let the analysts reply first in case there's something specific they want it clarified.
Yeah, I think we'd just like to make sure the committee is aware that the Library of Parliament analysts cannot give legal advice. They can only do legal research and provide legal information. But in terms of like the meeting of specific terms in the Emergencies Act, that might be borderline legal advice. So we just wouldn't want to get into that realm.
If I,
Mr. Mott's final word.
I don't get to have that final word very often, but I will take advantage of it, Madam Chair. Thank you. Can we add to the motion or to the suggestion for the analyst to also include what we have that's occurred at committee already in this invocation, not just the one historically from previous, but what we've had. I know Public Safety has had this conversation already, and I don't know if there's been any other committee, but any other committee that has had this Emergencies Act conversation be included in that material. So that'd be very good. Thank you.
Perhaps what
National Defense, Public Safety, I know.
Perhaps if you
Finance?
could just search committees where this matter's been discussed and provide that to the committee members. Does that cover what you're looking for? Okay. Well, thank you very much to everyone. And we're over time, and I apologize for that. On behalf of Mr. Fortin and Mr. Green and myself, we appreciate the opportunity to co-chair this committee. And if there are no other words, we'll adjourn.